Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
Hello. How are y'all doing today? Welcome back to another video. We are here to get into some transcripts, okay? Now, this is a court update from Megan Pete versus Milagro Elizabeth Cooper. This was a Zoom call that was had on September the 5th. This is a status conference discovery Zoom call. Now, before we actually get started, let's make sure we have our copyright disclaimer. As y'all can see right there scrolling at the very bottom saying that, hey, this is fair use. I am not a paralegal. I am not a judge. And I am not an attorney. I am simply saying that, hey, I know how to read and we got common sense. All right, so before we get started, y'all take a look here. This is from, as I mentioned, September the 5th Zoom call. Okay, this is a status conference discovery. All right, so let's go ahead and get started. We're going to start right here on line 2 with the courtroom deputy. So get your snacks, phone a friend, get you some water, alcohol, liquor, eat your dinner, and let's get into the transcripts, okay? Now, it is 53 pages in total, so it's going to be quite lengthy, so y'all bear with me. All right, so let's get started. The courtroom deputy, the United States District Court for the Southern District of Florida is now in session with the Honorable Lisette M. Reed presiding. The court, good afternoon. Mr. O'Sullivan, good afternoon, Your Honor. The court, good afternoon. So it took us a little bit to get everybody out of the waiting room and onto the Zoom. But we are all here, I hope. Miss Dixon, yes, she's there, and Mr. McLamont. All right, let's get with appearances. Let's start with appearances from counsel, plaintiff first. Mr. O'Sullivan, Your Honor, for the plaintiff, John O'Sullivan from Quinn Emanuel, and I would let my colleagues announce. Mr. Humphrey, good afternoon, Your Honor. Dan Humphrey from Quinn Emanuel as well. The court, very good. Miss Hayapetian, good afternoon, Your Honor. Mary Hayapetian from Quinn Emanuel as well. Okay, the defendants. Oh, Mr. McLamont, I think you are on mute. Mr. McLamont. Jeremy McLamont on behalf of the defendant in this case, Milagro Cooper. Ms. Dixon, good afternoon. Rhonda Dixon, pro hac vice, on behalf of Milagro Cooper. The court, very good. Is that everyone? Okay, all right. So this is a status conference on discovery in this case. I believe discovery, if I am not mistaken, is closing on July or had closed on July the 25th, and we had a couple of matters outstanding. Am I right on that, Mr. O'Sullivan? Mr. O'Sullivan, yes, Your Honor. In the state of play right now, we have been doing quite a bit of meeting and conferring since the last time we saw you, and a number of special discovery issues, I think, have been sorted. The third-party witnesses and the question, Mr. McLamont, and the other one were exercising better judgment, and we are just pursuing that in the destination court. The court, okay, Mr. O'Sullivan, and that we'll get where it gets, but between the parties, I don't think there are issues there. We have our pretrial order due today, and we have a draft that has been going back and forth that has exhibits, a witness list, and jury instructions in verdict form. I think in the real world, there will be some tweaking in, some nips and tucks, but the guts of it are there. I mean, the one issue that we have on discovery, I think right now, is we are asking for a 2-hour additional session with the defendant in her deposition. There were a lot of things that came out very, very late in the game, and then we thought she was going to testify at the hearing. We have not really heard her side on some of these things, and we could be very, very confused. As I said, max of 2 hours, and we can go to her in Houston. But for the sake of completeness, we want to ask her about the newly, just literally only that the newly produced stuff. I think we tried to work it out. And I guess last place we were, Rhonda, is you guys are not okay with that. Miss Dixon. No, because basically we've asked you several times to postpone it in complete discovery. You had hired 11 contract attorneys for the discovery in inalienable, and we were getting continuous results from that. But you knew that it was not completed, and you pushed through and did 7 hours. You could have done 4 and broke it up into 3, knowing that you had not completed discovery. And then very late in the day, you decided to put in a subpoena deuce tecum for some stuff, but you've got all of that. We have not even gotten the results of the subpoena, but I believe it is just the same as what we've already turned over. We turned over 1 terabyte of hard drive, and maybe it was 2. And everything that we could find from the backup, we gave you the Discord, and we gave you all the, you already have their phones. So once you receive the password in ID right now, you can go in, but you've got the password in IDs. You haven't asked for them before, and now you're saying that you want to do another 3 hour. She incurred substantial expenses coming to Los Angeles. We had a whole 7 hour. Well, you had a whole 7 hours. We went from that 9 a.m. to 6:30 p.m. She spent 2 nights in a hotel in LA, and we flew out there. We did all of that, and you knew at the time that it was not completed. We begged you to give us more time, but you didn't. So now you want to go. She will be available at trial, and I don't think you are suffering any undue. There's absolutely no inconvenience whatsoever to you because she will be there at trial, and any questions you have, you can ask her. Now you guys asked me about the stiletto matter. That was also a deposition in question, which she answered. And I asked her again, and she says she does not know who that person is. She has never met that person in person. She only knows them by the tag name Stiletto. So I just feel like it is just too much. I mean, we've done everything we could. You asked a whole bunch of interrogatories and different things like that, and we have answered all of your questions. And so another deposition, and you are representing to the court 2 hours. But the email I have said 3 to 4, and now you have broken it down to 3, and now you are saying 2. So it is just too much. I would have to fly. Jeremy or myself would have to fly to Houston because you are saying that you are going to use your Houston office. Now, there's some tea right here. We got some tea. Where's some tea? So it seems to me, look, we're going to pause. Pause. It seems that Queen Emanuel has a office here in Houston. Okay, so let's continue. To be in person with her, and we would like to be there if you are going to personally depose her. So that is a lot of expense for just a couple of hours. So I just feel like it could be handled differently. We already gave you the 7 hours that are required. We did not even have a chance to ask any questions of her because you took the entire 7 hours. So it just seems like you could have planned for it with the app, and there are records where we asked you to give more time and you said no. And then selectively, you want to come and ask the court for more time when you guys were here from the very beginning. We were confronted with something that was set up on April the 2nd when we weren't even involved and our schedules were not even consulted. So now you are asking us to give you something that we have already given you. We have provided you access to our client. You even had another hearing where it was 3.5 hours, where you played depositions and, transcripts and everything like that. We don't feel like you need to do another 3 hours because your estimates are always off. When you say 2, you told me 3 to 4, And I know it is going to be more than that. Mr. O'Sullivan, I'm willing to be held to two. The court, let me ask a question about you or saying there is newly produced evidence. What is this newly produced evidence and when was it newly produced? Mr. O'Sullivan, well, the easiest example is that Ms. Dixon handed me, a brick at Miss Cooper's deposition. So literally at that point, anything in there I did not have access to. And the court, that is something that you had asked for before, but you didn't get it. Mr. O'Sullivan, yes. The court, until the deposition. Mr. O'Sullivan, yes. And the only thing we are asking to be able to cover is new stuff we didn't have then. It is not like we want to go over in. I literally want to answer. I want to answer from her on the things that I have now that I didn't have that morning. And there is going to come a time when Rhonda is talking about us having the burden of proof and none intent for Miss Cooper. And we are dealing with a situation where a lot of things were deleted. So we have a big burden there. And I am trying to make it as surgical as possible of 2 hours. And I might not even use it. I am literally just going to get down to the key things that are new and get answers on that. So on that basis, Judge, we would ask you to let us do that. The court. So my question is, why didn't you have it before? So my question would be, Ms. Dixon, we actually gave that to him in addition to what we already given, the phone. We gave her a backup. So this was just in another backup to the drive because they said they were missing information. So this was another backup to the court. Okay. Ms. Dixon received before inaudible. The court. So if I could remember if Ms. Dixon inaudible, the court, can I ask a question before you, Ms. Dixon, gave them that? The court, let me just ask a question to clarify. I remember at the hearing, there was some missing text, Mr. O'Sullivan. Yes. The court, and missing gaps between WhatsApp text, Mr. O'Sullivan. Yes. The court, right? Are we talking about filling in those gaps? I am trying to understand exactly what evidence, Mr. O'Sullivan. No, my understanding is that stuff is gone. The court, okay, Mr. O'Sullivan, but there is lots of stuff that is clinging a core. The people that we are talking about in this case, Mr. Peterson and the other Mr. Peterson, direct messages with the defendant. The court, with them, Mr. O'Sullivan. That is more interesting than what we had before and more probative. I think, and we have not been able to ask her about that. The court, and they were on some kind of backup device that, Mr. O'Sullivan. The phone, yes. The court, okay. Mr. O'Sullivan. And even now, we are just getting the results. But in terms of when this should have come out, all these things are kind of rolling later, belated productions in response to document production requests from the beginning of the case. The court, OIC, Mr. O'Sullivan, all the court information that we are getting late, and the court. So it is not that you just asked for it. You asked for it at the beginning of the case, Mr. O'Sullivan. Yes. Yes, Your Honor. Ms. Dixon. Well, the court, and it has been a rolling. Okay. Let me make sure I hear from you then, Ms. Dixon. Why is that not true? Ms. Dixon. They are really wanting to. What they discuss with me in the meet and confer is that it is not based on the drive because the drive was given to them and we have had FTIs lifted the drive. Late, very late, We agreed to, remember, we agreed to an extension for depositions, and that was also, of course, subpoenas. Now, we would have that extension. During that time, they requested a second time a subpoena duces tecum to Discord. They had previously had a subpoena deuces tecum to Discord. We have given them the Discord information so they could take it directly. They could go directly on that site. And now I want y'all to get your notebook out, write that down, put that in your notebook. May have to refer to it later. You don't know, but hey, remember this. Write this in your notebook, y'all. So just to take a quick pause, it seems that they did subpoena Discord, but then they turned around, as in they, I mean Rhonda Dixon, Jeremy McLemont, and their defendant, their client, Milagro Elizabeth Cooper, had given the plaintiff, which is Megan Pete's legal team, access to Discord. So get your notebook out, write that down. Okay, let's continue. The court. Okay, give me dates. Miss Dixon. It was Discord and another one to Megan. So they are talking about the response to their subpoena duce tecum, which day, the court, from Discord and Megan, Miss Dixon. Put that in about 2 weeks ago. The court. Okay. And why did they put that in 2 weeks ago? Because they were not able to get it any other way. I do remember some. And then Miss Dixon. No, the court discussion. Miss Dixon, apparently they just wanted to be thorough because we had given them we had them follow up. And so we gave them the backup drive, which is everything that was on her phone when she, people get new phones, and she had backed it up to her external drive. The court, okay, Miss Dixon, and I actually asked her to do that just in case. The court, okay, so are you telling me then what he would have gotten from Discord and Meg would have been on that external drive that you gave him? Mr. O'Sullivan, no. Miss Dixon, yes. The court, okay, so Mr. O'Sullivan, okay, maybe I will let Mr. Humphrey, Miss Dixon. They are asking for now is that they want further deposition because of their subpoena responses. I don't know. We didn't get a response from them, but that is what I am. The court, okay, let's clarify that. Miss Dixon, hearing is the issue. The court, okay, let's hear it. Mr. Humphrey, Your Honor, if I could be heard. So what happened was we originally agreed to the forensic imaging protocol. That protocol revealed that there were massive deletions from the phone. The day of Miss Cooper's deposition, we were presented with that was purported to be a backup of her phone that filled in some of the gaps, but not all of the gaps. That did not have any social media logins. That did not have any WhatsApp logins. That did not have any of that information. So we went back to Ms. Dixon and to Mr. McLemont, and we said, hey, you produce some responsive social media direct messages on Instagram, Facebook, what have you. But we have reason to believe that there are many more. The court, okay, Mr. Humphrey, because we can see it from the screenshots that she did not give us the full threads. So they said about 2 weeks ago, here are all of her social media logins. So this is all of her social media logins. So we have all those social media accounts forensically imaged. And what we found, Your Honor, was there were massive amounts of responsive messages that should have been turned over, back in January of this year, that were never turned over. Do y'all see that? Y'all see that, right? All right, so let's continue. But we didn't get those until 2 weeks ago. The court, and you got them from Mr. Humphrey. They were from the court. And you got them from where exactly, Mr. Humphrey? From her social media accounts. The court? Okay. Mr. Humphrey, Instagram, Facebook, X, and y'all know X is formerly known as Twitter. The court, and these were not on the external drives, and you got these from Mr. Humphrey? Correct. The court? Meg. Mr. Humphrey, I think we have learned off the likely existence of them from the external drive, which showed the accounts where they would be. The court? Okay. Mr. Humphrey. And then we went back to Ms. Dixon and said, we need that expert forensics are saying, just give us the logins and we could get it all. The court? Okay. Mr. Humphrey. And so this is the court. So all of this is new data. Mr. Humphrey? Yes. The court that you were questioning her about? Mr. Humphrey? Yes. Ms. Dixon, the first time they asked for those logins, they kept saying to us that they had asked for them and they had been ordered before. But that was the first time we were ordered to give the Discord and maybe the WhatsApp. And she said there is no WhatsApp that is tied to the phone, and she didn't know of any external way to get into WhatsApp except for through the phone number that the court. But what I am hearing from them, Ms. Dixon, is that they did not ask for it before because they thought when they were asking for her phone and the external drive, they were finally getting everything. But it turned out that they could tell from the external drive that there were still other items. So that is when they asked for the logins. Your Honor, the court, Mr. Humphrey, I'm sorry, let me rewind it back. Mr. Humphrey, Your Honor, the court, is that correct? Mr. Humphrey, exactly. The court, do I have that right, Mr. Humphrey? Mr. Humphrey, so what? Ms. Dixon, remember is they ask the court, no, sorry. I just want to hear from Mr. Humphrey. I definitely will get back to you, Ms. Dixon. Mr. Humphrey? Mr. Humphrey, yes, Your Honor. So I will provide a concrete example that draws this out perfectly. So in the first request of production, that is RFP number 1 that was served in December of 2024 and due in January of 2025. We requested all communications between the defendant and anyone related to Ms. P, right? So she turned over some documents, a couple hundred maybe, but we know she talks about Ms. P a lot. Ooh, T. Okay, so let's continue. So we proceeded to meet and confer with prior counsel and said, we think there is more. We think there is more. She turned over her cell phone. We got more information about conversations she is having about Ms. P. We said, hey, and if you can remember, Your Honor, we came before you on July the 14th and said this Discord account, we think there is more responsive information in there. Now, we just got this Discord account, the full production, because it was so large, it had to go in batches a couple of weeks ago. So we haven't had all that material. The court, okay, Mr. Humphrey. And we said we think there are more conversations that you are having about Ms. P in your social media accounts. So Ms. Dixon and Mr. McLemont, instead of going through in review of those accounts themselves, they said, here are her credentials. You go and you see what you can find in those accounts. And what we discovered, Your Honor, is that there are substantial responsive material in those accounts that we just recently became aware of 2 weeks ago. The court, all right, but it all goes back to the first RFP that asked for all communications in that. Mr. Humphrey, yes, Your Honor. The court would go back in by April, you said? Mr. Humphrey, January of 2024. The court, January of 2024. Ms. Dixon, but how inaudible explaining things, because you're not saying that the information about Stiletto and stuff is not in the Discord accounts. You are asking for stuff. What you asked me is you were asking for things about her IG account, her Facebook account, and not her Discord account. And we had already given you, prior to her deposition, we gave you the logins to the Discord account. Miss Hayapetian, Your Honor, Miss Dixon. And we gave you the drive. Miss Hayapetian, Your Honor, if helpful, docket entry 90, filed on July the 11th. We had requested specifically WhatsApp and Instagram credentials, and that was the notice of issue before a hearing. The court, okay? So we are talking about July of 2025, okay? And what you are saying is you got some documents. You are discovering that there are other documents. You have gone out and you have finally gotten them, and you would like some additional time to discuss, to question the witness on this. And you will limit it to 2 hours, and you will go to her, Mr. Humphreys. Yes, Your Honor. Mr. McLamont. Could I guess the response from the defense side, the court, well, here's the thing. Ms. Dixon wanted to say something, and you were both from the same side. So let Ms. Dixon go first, or unless she wants to cede her time to Mr. McLamont. Cede my time to Mr. McLamont. The court, okay, go right ahead, Mr. McLamont. Mr. McLamont, thank you, Your Honor. So from what it appears, the plaintiff is trying to reopen discovery at this point to take a deposition, right? And Mr. Humphrey is shaking his no, but that is what is happening. They are taking a deposition, and it is a continued deposition that is normally 7 hours. They want to take a deposition of Ms. Cooper, and they are asking for discovery to be reopened so that they could take her deposition. I am just hearing about this at this hearing. I think that whether it is today, and they may have conferred with Ms. Dixon about this request, but this is the first time that I am hearing about this request to take a deposition of Milagro Cooper. So at this point, I am asking the court not to grant a request like this. This is a request pretty much by ambush, asking us to have Ms. Cooper have another deposition taken in this case. So Mr. McLamont think that this is an ambush on Megan's legal team side. Okay, y'all reading with me? You following up? Okay, let's continue. Ms. Dixon has turned over information to the plaintiff as pretty much a courtesy. So the extra hard drive, they should turn over. These credentials to her Instagram and social media accounts, all of these are things that Ms. Dixon turned over that necessarily she did not have to, right? The documents. You can propound discovery in a case, and you can ask for certain things that are relevant, but they are asking for entire logins, like logins to her social media accounts. And those requests, they are not necessarily relevant to the case, like to have the entire social media account. But Ms. Dixon gave those things over, right? And to have a whole hard drive for the phone in the backup for the phone, again, is not necessarily relevant to the case in which Ms. Dixon gave over the things that they are asking for. So here we are. Ms. Dixon has tried to comply. And remember, we get on this case, and there may have been discovery issues from December to January. As we get in, all we have done is over providing. At this point, we are over providing of what we think we don't necessarily have to. In exchange for that, the plaintiff is coming back and saying, hey, well, they gave us things that we didn't have before. So we should extend discovery and be allowed to take this deposition. They have had time since they got on the case, since they filed the lawsuit, to file motions to compel and to try to get these different things. They said themselves, hey, we know that there is more. We believe that there is more. At the time of December, January, February, March, and April, before we ever got on the case, they could have filed their motions to compel. They could have done that. They could have done what they needed to do. So now, after discovery is closing, they want to take another deposition of Ms. Cooper. They have already taken a deposition of her for 7 hours, and it is going to be a cost. Even if they go to Houston, one of the attorneys, one of us, either myself or Miss Dixon, have to travel to Houston. There is lodging to stay and all this different stuff. And it is going to cost more money for Ms. Cooper, who does not have the money to continuously defend this case in this matter. Now we're going to take a quick pause. Now, this is coming from Jeremy McLamont. Put this in your notebook, write it down. It is going to cost more money for Ms. Cooper, who does not have the money to continuously defend this case in this matter. Okay, so let's continue. So they've got their 7 hours. Discovery is closed. There is no real reason for them to take another deposition of Ms. Cooper in this case. The court, okay, so first of all, as I hear Mr. O'Sullivan and Ms. Dixon speaking, they have met and conferred on this issue. So before this hearing, they were talking about this issue, and they disagreed on whether there should be a continued deposition. So I do think it is ripe. I wasn't there, Mr. O'Sullivan. Yes, Your Honor. And I mean, we've got to 2 hours versus 3. I thought we were moving towards something, but yes, this concept was talked about today earlier. The court today, and Ms. Dixon, may I please finish? We have had 3 or 4 meet and confers, maybe more than that prior to this particular conference, Your Honor. And the first time they mentioned anything about this was this morning. I was on the way to a hearing in San Bernardino. That must be in California because she is from California. And the court, I see, Ms. Dixon, Mr. McLamont couldn't come because he was in a deposition. So they just sprang it on us, and we actually have talked to them this week at least 3 or 4 times. And this is the first time they mentioned the deposition and wanting to do an additional one. And I feel like she is going to be there at trial. She is going to have the expense of going to Miami for a trial. We can't do summary judgment motions. Well, yeah, we can't do summary judgment motions. So there is no undue prejudice to them whatsoever. They have everything that they need. They knew they didn't complete discovery. We actually asked them several times, why don't you wait until you complete it? Because we could see the FTI stuff coming in. But regardless of getting that hard drive, like they said, it did not give them much more than they already had. But they have not completed their FTI, discovery. So why didn't they just wait? It is an inconvenience to us, and anything on their part should not cause hardship on ours. The court, well, as I understand it, Ms. Dixon, and with that, I rest. The court, thank you. Thank you very much. So as I understand it, there was a request for all communications with Ms. Cooper, with regard to that RFP. And that RFP went out and what they, Mr. Humphrey, Your Honor, the court, I didn't catch that. It was muffled, Mr. Humphrey. Sorry, Your Honor. I believe it was December the 20th of 2024. The court, okay, Mr. Humphrey, it made it to January the 20th of 2025. The court, okay. And since that time, there have been some communications provided, but not all. And that is what you were trying to get, was all the communications. I am sure that you would have much rather gotten all those communications before you did the deposition. But here we are, right? Hold on, y'all give me 1 second. Let me burp. All right, thank y'all. Thank y'all. I know how y'all don't like, smacking and all that in your ears. So, we trying to take what we get and, just mute the mic when that comes up. But let me continue. So the question is exactly what kind of questions do you need to ask that we need this additional time for? What is coming up in this? I understand new evidence is new, but what is coming up in this new evidence that requires additional time? And that is what I want to get a sense of, Mr. O'Sullivan. Okay. And I think it is that we are literally talking about communications between what we would say are the different players in this. To Alisar Camps, to Peterson, Milagro. And in terms of knowledge of falsity and what is really being, what messages are being put out on what basis, who knows what about the basis or the source or any of that. And again, you are putting docs together, but you could see from the earlier transcript, we are able to get her state of mind by having 4 texts over 4 days as opposed to 2. And the ones that we are seeing are, we think probative of the state of mind we are trying to prove. The court, okay. So why is it that you are asking for this now today? Why has it come up today for the first time? I just want to make a record of that. What is your side on that? Mr. O'Sullivan, I think we have been trying to streamline our case and get kind of on the track for trial. And we have just been seeing this stuff, and we said, as a practical matter, this should not come up for the first time in trial. We need to at least get an hour with her and show her the most findings and, be prepared to deal with that. Again, we have the burden. We are suffering under, defendant imposed limitations on the universe that we will ever get because of the deletions. And we are going to get arguments that you don't have enough proof. Every communication from her to somebody who is doing something else at the time is going to get vital to our case. The court. So it sounds like you are going to lay these communications before her. And these are communications that came from her social media or directed to her from her. Mr. O'Sullivan, yes. The court, okay. And you are going to say, or are you aware of this, essentially? Mr. O'Sullivan, yes. And one of the communications around it, did you have to have that call? Did you talk about any documents exchange? Just the usual of who, what, where, when, but I think there will be some intent to the court. Okay. And then I heard you cut it down to an hour just now. So I think, Mr. O'Sullivan, well, I inaudible. The court, you said 1 hour. So I don't know. Ms. Dixon may have a right there. It is kind of like a moving target. So I want to make sure that I actually define that. So when the time comes, we can all agree on how much time is needed for this. So I will give you a minute to think about that. Mr. O'Sullivan, I think in fairness to both sides, I could do it in 2 hours. I don't want to rush and I want to get the questions right that may be used. So I would agree to a 2 hour limit on and, assuming not a lot of talking by defense counsel, but I am going to expect that. The court, all right, Mr. Humphrey, in 2 hours. The court, so Miss Dixon, Your Honor, this has to be by Zoom because honestly, I see this as too much. This driving, this flying here and there, either one. If they want to do this in person, they have an office in Houston and they want to do it in their office in Houston. It is a huge inconvenience for 2 hours or 1 hour or 3 hours. I think it is going to be more like 3 hours and they are just trying to butter you up. Mr. O'Sullivan, you can help me do it. Ms. Dixon. And so we went all day from 9 a.m. to 6:30 p.m. and everyone was exhausted and we did not have any time to ask any questions. So, all I am saying is that we should not be inconvenienced by this. And he did not actually answer your question, Your Honor. When you asked what was the substance of the questions, he gave you a vague answer. He did not give you any deeper inaudible. The court, okay, Miss Dixon, they cannot find that their theory is true, but it is not our fault. And we have given them everything that they could possibly have. And they can accomplish this by maybe further interrogatories, and they can. I don't see why it has to be deposition or why it has to be in-person deposition. The court, okay, I think a couple of us have low bandwidth here. According to my computer, it is saying that you have a bandwidth that is low. Ms. Dixon, I think I understand what you're saying. So you want to know if Alternatively, they can do this deposition, whether they could do this by interrogatory or if they could do this remotely so that you would also be able to be attending remotely. All right, let me hear from Mr. O'Sullivan and Mr. Humphrey on that. Mr. O'Sullivan, thank you. We don't have any objection to them inaudible. This is Zoom. A lot of people have been participating in the depots, but we don't want our taking of the depot be in person in Zoom is good for anything. But well, hold on, let me read that. I read that wrong. Let me read that. We don't have any objection to them. This is Zoom. A lot of people have been participating in the depots, but we don't. We do want our taking of the depot. I said depot, but depot to be in person in Zoom is good for anything. But and then the court says, okay, Mr. O'Sullivan says inaudible. The court, okay, so I guess I'm going to have to rule since the parties are disagreeing on this. As I understand it, this is documentation that has come in on a rolling business. The RFP was very clear in asking for all communications. It turns out that all communications were not immediately turned over, and there are some that have just been discovered about 2 weeks ago. We're going to take a quick pause. Y'all write this down, put this in your notebook. You might need it for later. So I am going to order that the party, Miss Cooper, appear for that deposition. It makes sense to me that it be a deposition so that there can be a follow-up question with regard to the responses. However, I think that it is reasonable to limit the plaintiff to 2 hours. Now, Ms. Dixon, if you wanted to ask questions yourself of your client, though, that may take more time. That might run over the 2-hour limit. That's up to you, but Mr. Humphrey, Your Honor, we are going to object to that. If she wants to ask her questions at the end, she is staying to do that. The court, but for the period of time when they start questioning your client until they stop is 2 hours. So you have agreed 2 hours, Ms. Dixon. So it has to be in person then? The court, yes. And you know, if they want to do it in person, Ms. Dixon, they want to have our client in there in audible with them. That is just not reasonable. The court, I understand. Ms. Dixon, that is not reasonable. The court, but it is totally up to you. Your Honor, this is Ms. Dixon. We could do it on Zoom. It could be ordered to be done on Zoom. They don't have to do it in person and flying to Houston. I mean, we do not have the resources to constantly move all over the place. And since it is a moving target, I am going to put on a timer and they are going to be timed to 2 hours. The court, that's fine. Ms. Dixon, or less. The court, that's fine. Ms. Dixon, but I don't feel like I should have to fly either myself or Jeremy. They are mandating basically that we fly in because they are going to be there with our client without us in the presence of her. And they could easily do it by Zoom, as they have done a lot of them by Zoom already. So since they already have had her in person, I just don't feel like they should be able to do another in person. It is a huge inconvenience as it is. It should be done. It should be by the Zoom. Everyone should be able to do Zoom. It should not be hybrid where they get to be in front of our client and neither one of us is going to be there because she cannot maybe afford to pay for our flight and accommodation, especially for 2 hours. Y'all write that down, put it in your notebook. So this is what we're going to take a slight pause. So as y'all do know, when it comes down to the plaintiff and when it comes down to the defendant, it is on the burden of the plaintiff and also the defendant when you do depositions or you need them. Like, for example, she's here in Houston. She has legal representation in California, and also she has local counsel in Florida. So California and Florida. And it's on the burden of that person, the client, to pay for hotel rooms, expenses, and so much as far as flight travel. So That's what that is. Okay, so the court, well, I understand that Zoom is one of the things that certainly since the pandemic, we have learned to use and we have always done, I guess, for many years, video depositions. But at the end of the day, the client chooses their own attorney and she has chosen California attorneys. Now, that is diabolical. And I guess Mr. McLamont, who is here in Miami, and that is what she has chosen to do, Miss Dixon, because it happened in California. It didn't even happen in Florida. None of it happened in Florida. Everything that they are complaining of happened in California. Now, that is also some tea. So, we're going to take a slight pause. Will this be argued in court? Will this be argued in court? Did Megan Thee Stallion at the time of the incident lived in California or did she live in Florida? This will be argued in court. And this is my opinion. Okay. Let's continue. The court understood, but she lives in Houston and she has decided to choose you as her lawyer. So she has decided to bear that and whatever expenses that go with that. Now, she could certainly go to California if that is what she wants to do for this deposition. But I think Mr. O'Sullivan and Mr. Humphrey are trying to make sure that they have an in-person deposition, supposedly. Mr. O'Sullivan, well, she could come to Miami, Judge. I mean, we are all in Miami and she could come here for the court. That's another alternative, Mr. O'Sullivan. At the end of the day, it is the defendant's trial testimony. The court, right, Mr. O'Sullivan. If it was a records custodian, we would say, of course, but the court. So that is my ruling with respect to the deposition, and it can be in person. If you agree to go to Houston, where she is, that's fine. Or if you want to have it in Miami, that's fine. But the plaintiff is entitled to have an in-person deposition. And if they are willing to go to the defendant, that is fair. Okay, so y'all write that down. Now, if y'all do take a look, I did already read over the court documents, and we do know that this will be had, but this is new information here. They're saying that, hey, well, not they, but the actual court, you can come to Houston or you can go to Miami. Either or. Mr. O'Sullivan, thank you, Your Honor. The court, I understand your concerns, Ms. Dixon, and the expense. I certainly do. I guess that my question is on, I should be available for Daystar in order to be available for Daystar Peterson deposition. Do we have a time for, okay, so this is, we got some tea, y'all. We got some tea. There's some tea right here. We got some tea. Okay, so here is the conversation about Tory Lanez's deposition. So this is the court saying this. I should be available for Daystar in order to be available for Daystar Peterson's deposition. Do we have a time for that? I understand that it is September the 15th. So that is in 3 days, actually. So if we take a look at September the 15th, that is next Monday. All right, Mr. O'Sullivan, September the 15th. I am not sure the time is pinned down. It may be, but we are working diligently to get you way in advance all the logistics and I guess just the different options. We want it to be the least burdensome as possible on you. So I think as soon as we know, but we are in touch with the prison and the people we dealt with in the past on this. So we should, well, in advance, have the time in the Zoom and, you know, all the things that we need. The court. So he's in California, correct? In prison? Mr. O'Sullivan. He's in California, yes. The court. So it would California time. And so would you be in person in California time, Mr. O'Sullivan? I will be there in person. The court. Okay, so it is probably not going to start before, I would say, noon. Mr. O'Sullivan, 9 o'clock local. The court, Miami time. Okay, so that helps. At least if I have another, well, hold on, let me repeat. At least if I have another hearing, I could set it for the morning, but probably I should keep my afternoon open. Miss Higher Patient, Your Honor, we close at 10 a.m. Pacific Standard Time, but we have not received trial confirmation. The court, and how much time do you expect to, Mr. O'Sullivan? It is hard to say, Judge. I think if it was just getting the answer to the 20 important questions, here, okay, so y'all some tea right here. We got some tea. So it seems that he's going to ask 20 important questions to Tory Lanez. All right, so let's continue. You could do it in an hour. If it is a lot of back and forth and invoking rights and things, it might be a little more clumsy, but I know I am going to be very efficient, and I hope I could do it if it is a mix of those three things in 3 hours. The court, all right, I will make sure that I keep at least that much time available. Okay, what else? What other discovery is out there? I don't know, Mr. McLamont. You're working on that in the California courts, Mr. McLamont. Yes. And DJ, okay, this is some tea, y'all. Got some tea. Yes, and DJ Academics in New Jersey. So we are just saying where we can get. We are engaged with the lawyers, with him, and everyone understands that we're going to do it in their local jurisdiction, and we will get what we get. The court, okay, very good. Anything else that I need to hear? Ms. Dixon, yes, Your Honor. We want to have permission to subserve Kelsey. Okay, we got some tea, y'all. We got some tea, y'all. This is some tea. This is ooh.
That was juicy.
Okay, so this is getting juicy, y'all. We want to have permission to subserve Kelsey Harris and Desiree Perez. We have made attempts to serve them. Several attempts that have not been successful. So we would want the court to grant us an order to serve them by substitution of service. The court, okay, these are non-party. Ms. Dixon for deposition. The court, witnesses that you want to depose. Ms. Dixon, they are non-party. The court, okay, and you have tried to serve them with the subpoena for the depositions and they have not accepted service. Ms. Dixon, I could send you the attempt of the affidavit of non-service and the attempts that were made. The court, and are these local Southern District of Florida individuals? Is there something that you would bring to this court? That is the next question. I mean, if it is a non-party in their deposition. Ms. Dixon, one of. The court, go ahead. Ms. Dixon, one of them has a home in Miami. The court, so you will try to serve her, will serve him, her, or her? We've lost a connection. The courtroom deputy, we have, and then it says inaudible. Mr. Humphrey. So if I could just fill the space. We did confirm this one, and we do not agree. At least the two names that she mentioned, we weren't able to get from her, from Ms. Dixon, a good faith basis to how they fit in this case at all in the efforts to serve is not going to be enough. So we objected in our meet and confer to that, Ms. Dixon. Actually, they did not. I recorded the meet and confer, and we did not discuss that. You said you were going to retract your request for the two people that you had said originally when you wanted to have this meeting. You wanted to subserve two people, and you said you were going to retract that request, and we were going to bring it up. But as far as you discussing anything about, you did not say anything that you were going to subject the subservice. And also, Desiree Perez is the client of the firm, Quinn Emanuel, and you guys said that you would not accept service on her behalf, and we had to personally serve her. So I'm sure she is dodging service. But the issue here is that on DJ Academics, even, he took a chat And you guys were saying he have to ask, well, we have to ask Desiree about this. She is clearly someone you know. And looking over the police records of Tory Lane's case, I see that Alex Spiro called several times to the investigating officer. This is some tea, y'all. We got some tea. We got some tea, y'all. Some tea.
Ooh, that was juicy.
So you guys definitely, and oh, I am sorry. Desiree Perez was noted to be on the line. So you guys do represent her, and you are saying you are not going to accept service. This is some tea, y'all. That's fine. So then we should be able to do substitution of service because we gave you notice. We asked you in the beginning if you would give us the courtesy of accepting service because we know that she is paying the bills on behalf of Megan in this case. And every single time when we look, she is in everything. Child. She was involved in this case from the very beginning. We want to depose her. She was there at the hospital, and she was there at the hospital, and she was also there on the phone when she called the police and changed her story. So we want her deposition, and I think it is very important to have it for this case. And so I feel like we should be able to substitute service. And you are blindsiding me because you never said that you were going to oppose it at all. That was not discussed. You said that you were going to retract yours and that we could bring it up to the judge and let the judge decide. So this is the first time I am hearing you say that you were opposing it. You never opposed it before. We said we wouldn't oppose yours. As a matter of fact, when you asked me, I have an email where I said we would not oppose your request of substitution of service as long as you don't oppose ours. The court, okay, Miss Dixon, and so the court, let me make sure I understand. First of all, we are dealing with Desiree Perez first, right? So let's deal with one witness at a time. So your understanding is that Miss Perez is a client of Quinn Emanuel firm, and you have asked Quinn Emanuel to accept service, Mr. O'Sullivan. And we have told, and maybe this is the question, the conversation that I am confusing, but we told Miss Dixon a while back that we do not represent her. The court, oh, Mr. Humphrey, we are not authorized to accept service, and we should go, well, and she should go about her business. The court, okay, Miss Hyapetian, and that was weeks ago, Miss Dixon. And they said they wouldn't accept service. They didn't say they do not represent her. But I have what you say, but I have other information. I mean, other complaints that were filed inaudible. Miss Hyapetian, not to put inaudible, but Desiree is in fact Megan's manager. She is Megan's business manager. She manages her affairs. She is involved in a lot of those things, but she is a human being and she works at Rock Nation and she has all these other capacities. We do not represent her in any of that. The court, okay, Mr. O'Sullivan. So we're not able to solve that problem. But again, just the kind of things that Ms. Dixon was mentioning, she would have known that the first day of the case. If she thinks that is important information for this case, they should have been looking for that depot or that depot, however you want to word it, on the first day of the whole case, especially if they wanted to take her depot. Miss Dixon, actually, the court at this rate, Miss Dixon, the court, I guess I don't have to. Miss Dixon didn't have that information. The court, oh, Miss Dixon at that time. Remember, I did not get involved into this case until June the 6th. They keep imputing knowledge and stuff to me. First of all, we didn't even open, and they know this for a fact. We could not open the zip drive for at least a week or two. So we did not have any of that information as part of discovery. The court, okay. Miss Dixon, okay. The court, so let me back up in Miss Dixon. If I knew that because I am going through this discovery, and as I am hitting, when I am getting prepared for one of the depositions that I had taken, that I wanted to take of Detective Stockner, and it was taken off. And when we were there, he told me he wasn't coming. But previous to that, I had one of the lawyers from the police protective league he told me would be there. They said it is a civil matter. We don't have anything to do with it. So he said he would be there. And so, in good faith, I set up and I incurred a lot of expenses trying to have a deposition. And they were there when he texted me that he was not coming, the court. So, who is he, Miss Dixon? That was the court. Desiree is a he, Miss Dixon, not Desiree Perez. This is Stockner. And so, in preparing for his deposition, I came, the court, I'm confused, Miss Dixon, to process the information, but I had already set the deposition for Desiree Perez because during the course of going through things, I saw that she was an integral part of this case. The court, okay, Ms. Dixon. But I set it in a timely manner, and I set it prior to the end of, we decided to do it prior to the end of discovery cutoff. And then we had that extension because it was set for July the 30th at first, or July the 30th or 31st. And then we had the extension of time. So I went to try to serve her again during that 20-day extension that we had in order to do depositions. And so I just feel like, in fairness, I should be able to subserve her. I made several attempts, and I can send the court the attempts and the money I spent on process servers, as well as in the case of the other person. But we will stick to Kelsey Harris. Yes, I made several attempts. But before I even did that, I asked them out of courtesy if they would accept service, and they said no. And they didn't say they didn't represent her. They just said they wouldn't accept service. The court, okay, so let's back up and do one individual at a time. You want to serve Desiree Perez. You have an affidavit from a process server saying that they made attempts to serve her and she is avoiding server. Is that all that you have? The court, Ms. Dixon, yes. The court, and I have not seen that. So you need to send that to the court. Ms. Dixon, okay. The court, so you simply want an extension. I mean, all I can do at this point is extend the deadline for discovery so that you could go ahead and try to substitute service to be able to depose her. But what I am hearing from Mr. O'Sullivan is that is not a problem for him, and that is not someone that he represents. And you do not have a dog in that fight. Is that correct, Mr. O'Sullivan? Exactly. I mean, my only dog is the reason I said before, which it is far afield. And I mean, we did try to get a good faith basis on one of those earlier calls for what would you really ask that would make it into evidence in this case, given the issues. So we don't need more to do, but it is my objection. It is not more or less than that. The court, and then going back to you, Ms. Dixon, how my discovery procedures work is that if you have an issue to bring before the court, you try to bring that within 2 weeks of the problem coming to light. So if you have been trying to serve her since July, I would have expected to have gotten information on this in August. Perhaps you were also trying to reach her in August. I don't know. I am trying to understand that. Ms. Dixon, yes, we were trying to reach her in August. The court, okay. Ms. Dixon, but actually we had originally tried to depose her right after May, or I think it was the 31st, and we wanted to do it on the 31st. The court, the 31st of Ms. Dixon, July. The court, okay. Ms. Dixon, yes. And then we had an extension, and so we decided to serve her during the extension. We had a time set, but I believe it was the court. So now I think your problem is we have other deadlines. And well, she said, as I have explained before, I cannot change any of the other court deadlines because when the district judge, the trial judge set a trial schedule and the dispositive motions and other deadlines that are necessarily to the trial, they set all their trials. So throwing off change one of their deadlines will change everything. But if the party agree that discovery should happen, then you are free to do that. So if you want to go ahead and substitute service and try to do that deposition, and Mr. O'Sullivan says he has no objections to it, which is what I am hearing, that's fine. Mr. O'Sullivan, well, I do object to substitute service. Just doing my job as a lawyer, because I don't think that's what is in that affidavit is what you need to do. So I do not want to say that. The court, oh, I have not seen the affidavit. Okay, Mr. O'Sullivan. I mean, I think maybe we could make one more very quick attempt to meet and confer about this, but it is not my dog. And then maybe Ms. Dixon makes the motion with a proper showing that she is entitled to this, and we can respond to it quickly. The court, that is what I would need for her to do. She is certainly do that. No, she can certainly do that in an email to the court so that we know what is that you're asking for, what your diligent attempts are, the declaration from the process server, and the dates in which all that occurred, so that we can all see it in, a copy to Mr. O'Sullivan and Mr. Humphrey. Ms. Dixon, okay. The court, or are you talking about the same? Is it Kelsey Harris? Is that another individual? Ms. Dixon, Kelsey Harris, yes. The court, and so I need some information about how relevant this witness is to the case so that we can all get that information else well. Y'all, give me 1 second. Let me burp. Okay, sorry about that. Ms. Dixon, she is relevant to the case because she was a witness to the shooting. But what they are basically saying is that they are upset because many people do not believe that she said, that this really happened. Or I am not saying that she didn't get, shot or know whether it was glass. There is a lot of speculation and there is a lot of also evidence that goes back and forth. But truth is the ultimate defense to defamation. And also, and so if she is saying that she was not truthful on the witness stand, and it is able to be proven that she wasn't, regardless of whether a jury believed it or a jury found enough to convict, if she is saying something different, then we need to prove that she is correct. The court. So is this a witness that testified during the trial? Mr. O'Sullivan. She testified at the criminal trial. Yes, and Miss Dixon, she did. The court, okay, so it seems to me that you have the testimony of this person under oath, and you are going to ask the same questions she was asked at a trial. Miss Dixon, Your Honor, she took the fifth in the court. Oh, she took the fifth at the trial. She did not answer. Miss Dixon, she took the fifth, and then she did the judge. Okay, so let me repeat this so I won't mess up. This is Miss Dixon. She took the fifth, and then they did. The judge declared her unavailable as a witness. He did get to briefly interview her like 2 weeks for, and they say that at the trial, and that is part of the appeal. We do not know what is going on there, but that is part of the substance of one of the issues in the appeal. There are several issues in the appeal, and that is why this case is important, because it is an ongoing appeal. Y'all write that down and put that in y'all's notebook. And the issue is that there are a lot of people that do not believe that. There is a lot of conflicting facts. And so I would like to get her to get on the witness stand and tell what really happened. The court. And you think that she is going to tell you something different than what she said at trial, and she is not just going to take the fifth? Mr. O'Sullivan, there is not a good faith basis to Ms. Dixon. I can't tell you unless I get her up. The court, I'm not. Ms. Dixon, I am going to ask her, get her. The court, I understand you want that. But at this point, we are now extending the deadline for discovery for you to have that. So it is a little bit different in there still has to be some jurisdiction for that, Miss Dixon. Some of the statements that were made were based on statements that Kelsey made. Like, for instance, one of the statements they claim is defamatory. Uh, what was that? She was, not the sharpest knife in the drawer or something like that, or that she wasn't smart or whatever. And Kelsey said that she did all of her homework for her. They have her back and forth, and they have an Instagram where she is telling her, "Oh yeah, I paid for your room for a year." And this was after this. So that was like, why did she pay for her housing for a year? And why did she, there are questions we have. Why did she do that? Was that a bribe? Was that for her to change her story? Because her story had been different too, and she had taken the fifth. And then she wanted to actually tell her story, and they claimed that she was unavailable as a witness. The court, is this relevant to the complaint? Does the complaint have anything to do with what she said about Kelsey Harris or about what Kelsey Harris said about her? Mr. O'Sullivan, I don't see the relevance, Your Honor. Mrs. Dixon, well, I did not see the relevance of Antonio Toll-Free and DJ Academic. But you guys called them anyway. You told me you had a broad discovery when we talked about the court. I'm sorry, I'm losing you. Maybe your bandwidth is low again, according to my computer. Miss Dixon, you are losing me. The court, yes, it says run in Dixon's network bandwidth is low. So what you are saying is very chop talk, and I am not able to hear. Can you try again? Miss Dixon, is this better now? The court, a little. Miss Dixon, okay, basically, if we feel it is relevant and she was in the trial and a lot of this is issue, almost everything that they are complaining about is about this trial and saying that she told the people that she did not believe her on what she said on the witness stand. And a lot of people that were at the trial had different opinions. She relied on some of the things that were said by Kelsey Harris. She relied on some things that other people said and did in the testimony that she saw, and that is why she was skeptical. So I would like to have her come to a deposition. The court, but I thought, Miss Dixon, as to that, the court, but I thought the lawsuit was about statements concerning Peterson. Miss Dixon, not the court. Do I have that wrong? Miss Dixon, Mr. O'Sullivan, I just think that inaudible. Miss Dixon, the lawsuit is about the statements that she was untruthful on the witness stand and that she was untruthful at several points in time regarding whether or not Daystar Peterson shot her or whether or not she was cut by glass. So they are saying that my client is accusing her of perjury on the witness stand. The court, right. So that is why I am trying to understand whether Kelsey Harris or whatever Kelsey Harris, let me correct myself, whatever Kelsey Harris has said, Ms. Dixon, this is relevant because this goes directly to the case at hand. I mean, basically in his case, there are a lot of people that are saying that Kelsey is the one that shot the pew, the GUN, even the witness. There was an eyewitness that said that, but yet they gave her reduced immunity because obviously there was some issue there and they declared her unavailable as a witness. So then her testimony was basically a coerced confession that she had with him. And so I would like to have her. And there are also other things. Look, every time I ask you regarding relevance, you guys sit up and say, well, you will find out once you get there. You have all of my peoples. You want their phone numbers and their addresses, but you never give me one of your witness phone numbers or addresses. I have several attempts that you have had in the last week or so to do that. You wanted to call Stogner and you want to call my witness up, but I could never call your witness up. The court, Ms. Dixon, I have no information on any of your witnesses, and you never gave me Antonio Toll-Free, and that is actually another. The court, Ms. Dixon, Ms. Dixon, yes? The court, I want to try to stay on this issue. Okay. Are you going to also send me information that you have made diligent attempts to? Ms. Dixon, yes? The court, serve this person that there is a declaration from the process server and that you have been trying to do this within the last 2 weeks. Mr. O'Sullivan, in your honor, if we could ask that whatever the submission is, that it addresses a good faith basis, just in terms of number one, I mean, Miss Harris testified at trial. She said she did not shoot Megan. She is not going to be helpful to them. She did not take the fifth on everything. I cannot imagine realistically what she could possibly say at this point. But if there is something that Ms. Dixon thinks she could realistically get from her, then that should be included, because I think that she is out of the jurisdiction. She is not our witness, and we do not have any contact with her. The court? Okay. So because we are extending discovery here, I want to make sure you have made the diligent attempts while discovery was still open to attempt to serve this individual and the declaration of that diligence from your process server, and how this witness has relevance to the case, so that I can understand why this is so important that we need to extend the deadline for it. Thank you, Your Honor, says Ms. Dixon. Mr. O'Sullivan, yes, Your Honor. The court, all right, so that is two individuals that the defendant wants to depose. You brought up another name. I was not sure if that was another individual that you wanted to depose, or if you were just comparing that situation to another situation. Ms. Dixon, that is what happened. I'm comparing that situation to another situation where there was no relevance. And then his attorney actually cut it short when they started talking about it. FBI investigation, girl, that's some tape. There's some tea, y'all. There's some tea. Okay, get your ears out. We're going to read. And I wanted to bring that up because there was an individual online who claims to know Megan, who says she is related to the Houston's PD and the Houston FBI.
Ooh, that was juicy.
We need to, y'all write this down. Put this in your notebook. This is a question. Is Megan the Stallion related to Houston Police Department and the Houston FBI? We need to investigate. Well, not investigate that, but, put that in your notebook. We need to hear about that. But anyway, let's continue. And I called the number that they put on that they posted as an exhibit on Antonio Tollfree's deposition. When I asked them about the relevance, they said, you will find out when you get there. And based on when I got to the deposition with no idea what the relevance was, they were saying something about a Camp Mob, which was in 2023. And she had a meeting with all of her followers. It had nothing to do with Megan. There was no discussion about Megan. There was nothing in that whole thing that had anything to do with Megan. So the attorney for Antonio Tollfree finally cut it short. He said, look, I have not heard a word about Megan Pete for over 30 minutes, and this is over with. But we are asking for the relevance, and they did not have any relevance. The court, okay, Ms. Dixon, it was that they were intent to put some kind of criminal charge on her that they had gotten in other cases. Now, this some T-Raw.
Ooh, that was juicy.
Now, y'all need to write that down. Put it in your notebook, what that means. Okay, so let's keep continuing. The court, okay, but I am not sure that there is anything that I can do about this at this point. This is something that already occurred and the deposition was terminated. I understand. I am just trying to make sure if there, Ms. Dixon, there is. The court, is anything outstanding on discovering that I can help the parties with? Ms. Dixon, that was not a discovery issue. That was an issue of trying to attack a case collaterally. Y'all give me 1 second. Let me burp. Okay, sorry about that. By trying to institute criminal proceedings already gained advantage in this civil proceeding. The court, okay, Ms. Dixon, that's my issue there. The court, okay, all right, Ms. Dixon, and I can fully brief it, Your Honor. I would actually like to brief that and have another brief on that. The court, so it sounds like you are trying to ask for sanctions or something. I am not clear on what that is about, Ms. Dixon. Yes, the court, okay. Ms. Dixon, I am going to do a motion in lemon or lemon, however you say that. I am also going to do a motion in lemon regarding that because I don't believe that it is relevant to this case at all. The court, okay, well, that is something that you would file within the deadlines with the district judge. Okay, that is something for Judge Altanaka to handle. All right, so having completed everything here, I just want to make sure that with respect to the deposition, the continued deposition of Ms. Cooper, that you submit in order, Mr. O'Sullivan, that you will also make sure that you show that to Ms. Dixon and Mr. McLamont, but that limits you to the 2 hours in person. And that if there is additional time, if Ms. Dixon needs additional time to then redirect for her client, she can do so to ask additional questions. Okay, Ms. Dixon. Yes, Your Honor. The court. All right. Thank you, everyone. Ms. Hayapisha, your order with regard to the court. Yes, Ms. Dixon will be sending me information regarding this substituted service. Very good. Ms. Dixon, thank you, Judge. The court is adjourned. Ms. Dixon, thank you, Your Honor. And that is the end of this. So we did hear about a few things. All right. We heard about a few things that is in question. And we all have opinions. What do you guys think? Leave your comments below. If you like what you see here, like, share, and subscribe. And this is getting interesting. This case is getting very interesting. But what did y'all think about the September, as y'all see here? This was September the 5th Zoom call. What do you guys think about this Zoom call based off of what I just read? Let me know below. If you like what you see, again, like, share, and subscribe. I am shooting for 500 followers on YouTube. So if you like what you see, please hit that follow button. It's free. Please hit the like button. It's free. And I'll see y'all next time. Peace.